clients, and we help get the right results that they're looking for. Coleman?
Thank you for the introduction, Ben. My name, as he mentioned, my name is Komal Mirza. I've actually known Ben my entire life. My practice is primarily focused around assisting employers and employees navigate their employee contracts, taking a look at non-complete clauses and navigating those, assisting with risk management, and also with facilitating the practice group formations as well. We've been at this for a few years now, and I'm looking forward to today's presentation with Ben.
Well, thanks. Okay, all right, so let's get started. And here is can everybody see this slideshow? And here we go. All right, so today, the title of our seminar is Risky Business. We named it after a film, 10 Tips to Actually Risk Management. And, the question that comes to mind as the attendees are enrolling in the seminar is, why are you here today? And, in some form or fashion, you're involved in healthcare. And I'll give you a quick story. I get a call one day, and this story is really about the backside of things that happen. And then there's like a front side of the public facing side. Then there's a backside that happened. And I'll walk you through the backside story, which doesn't get documented anywhere or shows up anywhere. But I get a call one day from a physician, and she says to me, "Hey, Ben, I've been getting sued. I've been involved in this lawsuit for almost 2 years. What do I do?" And so I speak with her as to what happened. And she says, well, there was actually a blood test that was done that showed elevated levels of a particular enzyme, and they missed it. They forgot to actually they didn't get to actually get a chance to call up the patient and talk to them about those blood test results. And what happens 6 months down the road is that it's an ovarian cancer that becomes unrecoverable, and soon thereafter there's an actual death that takes place. And now the spouse of the deceased is suing the physician as well as the physician group that she was in. So, here you have a perfectly good physician who missed having a consult on a blood test result with a patient. And it was because the blood test results came into a electronic system. They got uploaded, and for some reason it got missed. Nobody made a phone call. Nobody read the actual results, and the physician felt horrible. So, in the meantime, when this lawsuit started, there were actually a lot of attorneys on it. The battle had already been going on for 2 years. And that's when I get contacted. So when I get contacted on it, I go through the scenario of where we are in the actual litigation, and I find out that there's some proposed settlement offers that are out there, which is great. But now it's like I actually want to not just talk to the physician, but I want to talk to the administrators of the enterprise that's involved, because now I want to figure out how to settle this the right way. So I get called into it, and from the backside. Remember, I don't represent the insurance company in this situation. I'm only there to help the physician and the administrators get through this bad ordeal that's already been going on for 2 years. And there's actually huge damages clause at the end of it all. So when I look at the actual proposal for settlement, it's really pretty mediocre. In comparison to a death that occurred, the damage, what's been proposed out there is fairly small. And you can see all of these now repercussions happening, right? So first of all, there's a blood test that gets uploaded into your technology system. There's a missing of it in terms of the consult that takes place. And would a consult have taken place, there may have been a referral that could have been made to the appropriate specialist. There's a lot of misses that happen along the way, and now you've got a disgruntled spouse that is now suing the enterprise as well as the physician. Before we settle this out, my biggest concern is, how am I going to actually save the license of the physician from getting dinged? Because number one, it's like, the physician feels terrible. It never should have happened, but the physician didn't take an active role in it, right? Something along the way got missed. So today's seminar is really about that, right? How do you handle these sorts of innocuous situations that are occurring, but are critical to the patient care that we provide. They're critical to the business. They could, you could sink or swim on some of these things in and of themselves. And so I walked through that story. I walked the actual physician and the enterprise through this, and we eventually do get the case settled. There is no ding on the actual physician's license, and the physician can continue to go on to practice. That's how that story ended up, luckily. But many times it doesn't. I've actually had physicians that came to me after the fact and said, "Hey, what do I do here, Ben?" And I'm like, "Is the case over?" Yeah, they're like, "It's over. It's already been settled. It's done. Like, I can't help you now." So in those sorts of situations, I actually help them, and it's a very personal story to me because it matters to me on all fronts. First of all, starting off with a patient. Patient should have actually gotten better treatment. There was in fact a lapse there. But at the same time, the physician who couldn't sleep at night because of what had happened, you feel god awful terrible for them because they're going through this very personal sort of a turmoil. And so what can you possibly do? So today what we're going to talk about is really about those sorts of scenarios and how to handle them and how to manage them the right way. So just starting by way of background, I actually have been practicing law for almost 20 years now. I think within about another month or so, 2 months in April, it will be 20 years. And, I'm formerly a CPA. I think of things in a very business sort of a setting. I think of it as, cost benefit scenarios. And I look at things from a very nuts and bolts perspective every time, whether I litigate or whether I'm doing a contract or anything else. So that's my background. I've litigated, like I said, maybe like 2,000 cases. And of those 2,000 cases, 500 cases were solidly complex, multi-parties, multiple issues, lots of claims and counterclaims and cross suits. So that's my background. Usually I have Ed Meyer, who joins us today. He's on a flight from California to Texas at this time. And I also have Komal, and so it's the three of us that actually work together, and we work with our physicians, practice groups, and all the other healthcare companies. So the question is, why is risk management important to you? So let's start off with the financial and reputational issues, right? So why is a malpractice lawsuit important to you? In that scenario that I just played out for you, man, like, you've got a lot of money in the hopper. If you don't get it resolved the right way, you could potentially be at risk as an enterprise for additional monies that your insurance company will not cover. You've got reputational damage potentially. You've got licensure issues that come up. I mean, your business comes under fire for having not done something exactly the right way and getting reported to the agencies and so forth. So you've got all of those issues, and it's a whole conundrum. And then you can also have other issues like for example, Medicare billing issues. If you are not doing those properly, you could run into like a regulatory mess. And there the big question is, can you do without Medicare and avoid that whole risk? And most businesses, the answer is no. They cannot do without Medicare patients or the Medicare business. And then, last but not least, everybody talks about property and technology coverage and the risk management there. And we'll touch on that as well. But today I'm really going to keep this very centered to healthcare. So if you actually take a look at the picture on the left of the screen, you see a boat, you see waves, you see people taking on water, and you see 5 guys working on building their own little ship while they're tearing apart the rest of the boat. And the reason why I chose this picture is for several reasons. Number one, the boat is the enterprise, right? These guys are cutting up the boat just to insulate themselves, but forgetting about everything else. So just remember, risk management is a team approach. It does not work if you're in a silo. The other thing you'll notice is these 5 people that are on here, they look identical. Same black suit, same black hat, same stuff, carrying the same shoes, everything, right? So what that tells you, to me, what that meant was you got to have diversity of thought, diversity of discipline. You cannot do risk management alone by literally just looking at the black and white nuts and bolts, the CPA accounting of it. And you cannot do risk management alone just by looking at the legal component of it. You cannot do risk management alone without looking at, without the patient component of it. It's a team approach. So the team matters. It's a team approach. You got to do it together. And diversity of thought and discipline matters. So involve people from all different aspects of your enterprise. So today's roadmap is we're going to talk about healthcare operations and risks, the different types of insurance policies that are out there. We're going to walk you through a little bit of like the nuts and bolts and the critical things you should be looking at. And then we're going to talk about alternatives to traditional insurance. What other things can you do to actually bring down your cost of insurance? And then last but not least, and I think it's the one that's actually the closest to my heart, which is what to do when an insurance claim arises. In the end, we'll have about 10 minutes worth of time, hopefully, to have some questions. And that's where we'll go. By the way, you take a look at the picture on the left. It's about profit and loss, and risk is right in the middle. You can actually tank your profits if you don't plan your risks properly. So that's why I've used that picture there. Now let's go through healthcare operations. Think of healthcare operations, just like we talked about that blood test results, as a handoff, right? So here come in lab results, they get uploaded into your system. When they get uploaded into your system, that's a handoff. Did those blood test results come in accurately? Did they get reported up into the right fields? Did the right triggers get triggered so that it could be reviewed properly? And obviously under the scenario I just told you guys about, it did not, right? It didn't happen that way. So with that, just keep in mind you've got patient care, you've got scanning of things, you've got testing, you've got lab results. Even if you're thinking about offering some kind of a transport benefit to a patient, there's a risk and a reward in that. There's a handoff that's occurring. You got to consider those things and whether it's worth it or not. If you look at information technology, electronic health records, the billing systems, there's, again, you got to look at what are your exposures there. Are you open to like cyber attacks? Are you vulnerable to your electronic health records getting stolen or tapped into or copied over? Is your billing being done properly? These are all risk management issues where you've got to make sure you've got enough safeguards in place. Now, for some of you guys, you are from a hospital system. When you go into a hospital system, you can add on another layer, right? A hospital system offers not just the actual patient care component and all that stuff, but it also offers like food services and janitorial and laundry and environmental services. And you got elevators and ACs that are an integral part of a hospital. And each one has a risk and a reward scenario built into it. Each one has a handoff. What if you have a air conditioning system that's kind of a closed loop system where it's circulating the same bad air into the same place, and there's a contaminated patient that's going to now share their germs with the rest of the half of the floor that air conditioner services. So you got to keep those things in mind. Even if you look at janitorial stuff, right? Is the janitorial service company, whoever you use, I mean, there's a bunch of them out there, anywhere from, are they using the right chemicals? Are they using the right concentrations? Are they staffing it well enough so that your cleaning is being done properly, that the sanitation, the sanitization is being done properly? If you think about it, almost every healthcare business that you can think of on the provider side involves at least 4 of these aspects that are listed in here that are handoffs, and they at least 4, probably more. But you got to think through these scenarios in a really detailed sort of a way, understand where they're connecting to each other, understand how you're going to implement your risk management plan. So tip number 2, think of the strategy that you're about to invoke, and think of the risks that are involved in it and how you're going to cover those risks.
And
All
while
right.
this, seems very complex, as Ben's explaining it, there is a way to kind of make it so that it's almost second nature to you and your practice and all those that you work with. But the key point is really just making sure that you address each of these potential fallout areas.
Thank you. So risk has several categories, or actually it could be quite a few categories, but here are the generally widely accepted 6 categories that we have here. One is the operational risk, which is your workplace safety, infection control, and the equipment that's involved there. You also have human capital risks, like whether it's your employment practices, it's the vetting of those individuals, it's their terminations. Did you do it properly? Did you not do it properly? And it's also shifts, right? Did you provide enough coverage for a particular shift that was supposed to take place to take care of the patients that were going to show up in your ward or in your practice? There's a whole human capital risk assessment that's got to be done. Then there's also strategic risk, right? When you apply for a reimbursement with Medicare, is there going to be a repercussion to it? You got to figure that out for yourself, but you can bring in consultants to like help work through that scenario. There's a competition risk that's involved. There's actually alliances you can build and affiliations, and each one of those alliances and affiliations that you have has its own strategic risk associated with it. So consider those. There's legal and regulatory risk, like we talked about earlier, the anti-kickback rules, the Stark laws, the compliance issues that arise. There's a technological risk. The technological risk basically means electronic health records to barcoding to even robotic surgery. And then you have the hazard in general, right? So your regular property damage sort of stuff like storm, wind, fire. Let's say you have an aging infrastructure of like whether it's elevators, escalators that actually fall apart, and now you've got people that are kind of getting dinged up as they take your modes of vertical transportation in your building. These are all general sort of risks that you have, and you got to make sure that those are also buttoned down. So here are now the actual insurance policies you can use to hedge against those risks. First there is, professional liability, right? Oops, go back. Professional liability. Professional liability risk is about the malpractice stuff, right? Errors and omissions. But there's a whole ton of other types of insurance policies you can invoke. Yeah, I'm sure you guys are aware of workers' compensation, which is always work-related injuries. But what if an employee has non-work-related injury in an employer setting? Like, for example, like workplace violence. It's not work-related per se, but it happens in the workplace, and the employer is responsible for making sure that there's a relatively safe environment, without all of those bad situations that can arise. I mean, you can't guarantee it, but you got to take the reasonable steps that are necessary. So there's also what's called employer liability. In case if you didn't understand that difference, I wanted to lay it out and make sure that everybody understood it. There's also directors and officers insurance. As you know, it covers the board of directors and the officers. There's what's also called fiduciary. So how is fiduciary different from directors and officers? Well, fiduciary insurance covers the employee assets like pension plans and the benefits that the employees get, because the management of the company is now responsible for managing the employees' assets. So it's considered fiduciary responsibility to the employees. So that falls under typically fiduciary. You obviously have property damage, which goes into building and furnishings. And then some of you may know this already, which is machinery. Machinery includes insuring things like elevators and boilers and air conditioning components, because things can go wrong there too. Not too long ago, there was a building on Miami Beach. There was an actual boiler that blew up. It blew off the rooftop of a condominium building in Miami Beach. Now, if you can see that happening in Miami Beach in a condominium building, imagine that happening in any of these commercial buildings that we go in and out of, right? So you can have machinery insurance that'll help you cover those things. And then you also have your general liability insurance, which is like the slip and falls, and it's kind of like the catch-all of when things go wrong. Also keep in mind, I still haven't talked about the mundane sort of stuff like auto insurance. There's also really unique insurances that you can buy too. Like for example, event insurance. Did you know that these foundation galas and tennis matches and car races, you can get an event insurance for that? Meaning like what happens if there's a rain out or something doesn't go right? You can actually buy event insurance for that. That's a really unique situation, but there are people selling that sort of insurance. You can buy it for those unique situations. Now, the one thing that I want to point out to you, what's not on here is, any guess? Any guess? Okay, well, since you guys are all on mute, I guess I have the right to
COVID
talk.
insurance.
Which one?
John Mackler. Insurance because of alleged implications from having COVID-19.
You know, I have not seen a COVID insurance policy yet, but that makes good sense. That makes good sense of having it.
Real quick, I was in a store outside of Atlanta, Georgia, a few weeks ago, and there was a sign that said, I don't know if it was binding or not, but it said, if you attract COVID from our store, you are not entitled to sue us. So it just made me think about that.
Yeah, that's a funny sign. I mean,
Yeah,
I have not seen that sign yet,
it?
but yeah, that's great. You should have taken a picture of it.
No, but it was actually true. I mean, they were representing that you don't have the ability to sue them. Similarly, like when you park in a parking garage and they say management is not responsible for, doesn't assume any liability if there's, bodily injury or damage to your vehicle, which I don't believe is actually binding. But
yeah, I don't think it sticks either. But yeah, but they have it just to take care of the regular day-to-day trivial, $200, $300 type of claim.
Sure.
Sorry,
Yeah, didn't mean to interrupt you, Ben.
No. That's great. I'm glad it's hard to actually interact on this electronic medium, but I'm glad you mentioned it.
What about cyber insurance, Ben? I don't see cyber insurance there.
Yes, cyber insurance, absolutely. That should also be on here. And any other suggestions? How about
would
excess
HIPAA fall
insurance?
under cyber as well?
Say it again.
Would HIPAA PHI breach fall under cyber, or is that a external policy to that?
It should. HIPAA is generally covered under another policy, one policy or another. You got to find out and read through your policy if HIPAA violations are covered under your professional medical malpractice issues or directors and officers or E&O. I mean, it could be any of the above. It could be involved in, and also if you get a HIPAA issue, can you tap into more than one policy, right? So if you're actually going to go and defend against the claim, and you've got damages that are coming up, can you tap into more than one policy? If it's covered under more than one policy, you get to tap into all of them and have them work together to bone up that defense and the damages. So it's really so the excess liability is what I wanted to actually point out. Excess liability, I intentionally left it off because I wanted to kind of jog everybody's memory. Is excess liability, what happens if you blow through your $2 million or $5 million limit? You need excess liability insurance, and that is a super cheap insurance, easy to get, and has a huge umbrella effect to it. Anybody? John, was that you? All right, next thing.
Not me.
Okay. All right, next thing. Let's talk about actually occurrence versus claims made insurance. Everybody talks about different types of insurance policies, and you got to really understand these two different types. So each policy will be either an occurrence-based insurance policy or a claims-made insurance policy. And the easiest way for me to explain this to you is this diagram right in the middle, the green and the red. Komal, you want to touch on this?
Sorry, sure. So the occurrence form policy is primarily the major difference. Let me start with this. The major difference between occurrence form and claims made policies is that one will provide tail coverage for claims that are brought in the future, whereas one will not. The one that provides tail coverage or continuous coverage, regardless of whether the policy is still standing, is the occurrence form. And that usually tends to be a little bit more expensive than the claims made policy, which is specific to the time period of the policy, meaning that if a claim arises during the policy, it also has to be filed and brought forth during the policies, while the policy is in place. A lot of times, you know, employers will have claims made. Sometimes they'll have occurrence form. But the major thing there is that you want to make sure as an employer or even as an employee that you want to make sure that you have some sort of tail coverage after your employment, after that policy expires. A lot of times you can add on the tail coverage with claims made. It could be a little bit of a surcharge. You need, you know, and that's really going to depend on what kind of coverage you look at and what kind of policy is in place.
So one of the things that I've actually seen used really pretty smartly by different health systems is that they will offer their new practitioners almost like a gap coverage. If they're leaving one employer to come over to them, what they'll say is, we'll pick up your tail coverage that you owed the former employer. And for the actual health system, it's like a minor upcharge. But what they've done is gotten a huge value out of the goodwill that comes out of it. And it increases their whole recruitment, right? And the physician feels much more secure going on to a new employer. So that's one thing. The other thing is, let's say that the physician gets sued while they're employed under employer number 2 for something that they had done with a former employer. That has a whole other psycho, it'll affect the person psychologically, motivationally, how much they're able to work and so forth, right? So what they've kind of done is, as the new employer, they've kind of helped the physician, you know, bridge that gap, get it, feel safe about it, not have to worry about these things that could be coming at them, and help them, you know, just come into their system. And I tell you, physicians appreciate it so much that I've actually found them giving up money with other employers just to go with an employer who will cover them for the tail coverage component.
That's exactly right, because they tend to be risk adverse, right? So they want to make sure that they're covered.
Yeah, the physicians, yeah, you're right. Physicians are very risk averse. They just don't want to be without coverage.
Right.
Okay. So when it comes to a policy, what are you going to review it for, right? So you got to review every policy that you get. You got to understand its basic nuts and bolts. And here are basically 6 things that you got to look at. Number 1, know your time periods. Put them on a spreadsheet, put them on a calendar, but know your time periods. It begins on January 1st, ends on December 31st. Know those specific dates and when you got to renew. Next thing is know your dollar limits, because every policy doesn't just have $1 limit. They'll have oftentimes multiple dollar limits for different types of events. They might cover you for $500,000. For another type of event, it might be $2 million. So know what dollar limits are playing out in these policies. The other thing is deductibles. What are your deductibles going to be? Is it $250 or is it $250,000? Right? You got to look at those deductibles. Como, you were going to say something?
Yes, I was actually going to interrupt you. Going back to the limits issue, you really have to make sure that you know what the limits are, not just for coverage purposes, but you also have to pay attention to state law. Florida, for example, does require minimum coverage as far as limits are concerned. For practitioners, it starts at $100,000 per claim, and with a $300,000 annual aggregate. For surgeons, the minimum that's required is $250,000 per claim with a $750,000 annual aggregate. These numbers, you know, generally depending on your area of practice, tend to be on the lower end. So it's really important, you know, that you speak to a professional and that you get the right advice in terms of making sure that you have the right amount of coverage with your policy.
And then the other thing that you have to also make sure is whether the activity that you are doing is covered under the insurance policy. If you look up professional medical malpractice insurance, if you are running a lab within your clinic, will it cover the lab testing that you are doing for those patients that are coming in? So I would ask, I mean, you got to know these things. It's a part of the activities that you need to know whether they're covered or not. And then also remember, insurance policies are funny. What is not specifically excluded is deemed included. So that means that if the policy does not specifically say that we are excluding this, it's deemed included. So find that out. What is specifically excluded? There are often exclusions that ride along as an attachment to the back of these policies, and you got to look at those. You got to see what they're specifically saying. It looks like a lot of words and a lot of verbiage, and they're boring as heck contracts. But if you actually go through the meat of it and play out some of these scenarios, like the one that I just started off with the whole blood test and the transmission of the information into a new system, you'll see like those kinds of scenarios really add life to those policies. So, if you don't have time to go through that stuff, get your in-house legal counsel to do it. Have them help you review it, and even then, I don't. A lot of in-house legal counsels don't have the background of litigating these cases, so you got get the right counsel on it, whether it's us or anybody else. Get the right legal counsel and walk through those scenarios. Remember, you're only going to do this once every few years. You're not going to do it all the time. You don't need every single policy reviewed, but you need to reset your button and your compass so you're going down the right track with the right way of thinking, and then you know what kinds of things you're going to be looking out for. So, another tip to actually look out for is ask your policy coverage companies, right? So the insurers, ask them if they cover non-physician advanced practitioners. So like you have a nurse practitioner, like you have a PA, right? Are those kinds of advanced practitioners covered? And then ask your providers if they will cover state board investigations, because like if a state board conducts an investigation against your practice or against the individual itself, they're going to have investigators all in and out. You need legal coverage on those kinds of things, and if you don't get it through a policy, then you have to go out on your own. But find out if that's actually covered, because again, it's an outside attack coming at you. You need to bone up on your legal defense. These insurance policies do have a way of including that, so ask for it. All right, so now let's say that you've got insurance policies and they're getting way too expensive. Well, what are your options, right? So, one of the things that you can actually to reduce the cost is to increase your deductible. You can go for, like I'd mentioned earlier, you can have a $250 deductible or a $250,000 deductible, depending on your level of risk that is appropriate for you and your company. For example, when I had my own law firm with in another lifetime, my deductible there was $25,000, because $25,000 didn't matter. And now, because we are a smaller law firm, $5,000 actually matters. So I actually chose a $5,000 limit, right? So it matters as to the size you are and what you're willing to put out as a deductible. So if that doesn't work for you, number one, then go on to, like, let's say, consider number two. Number two is actually a self-insured retention plan, where you actually have a trust, where you're actually you have money, you're self-managing those claims. You are, you're kind of driven by actually state law statutes, because each state law has its own requirement for self-funded insurance, but you got to follow that sort of stuff. If you need an actuarial analysis. And most plans actually have a excess insurance policy on it. So, for example, if your self-insurance fund only has in it $2 million, what happens once you blow through in a given year? What happens if you blow through that $2 million? What's going to happen to the third and the fourth and $5th million? Well, that's excess insurance, and that's what's going to help you pick that up. Another one is what's called captives. I've actually never seen this done, but I've heard about it and I've read about it. It's actually a closely held insurance company that's run onshore, offshore. That's a different model. I'm not that familiar with it, but it's another possibility. If it's something that's of interest to you, you can do it. And there's just literally like insurance agents that'll help you get that set up. There's bankers that'll help you set up the right bank accounts, whether it's in Bermuda or the Cayman Islands. There's a lot of things going to be done with this stuff. The fourth one, which is actually used fairly often, is called the risk retention groups. These are groups that are practicing in a similar sort of a way, in the same industry, and they go in it collectively. And so like, let's say I am a behavioral health group. I find another behavioral health group and another behavioral health group. And it's like 5 of us groups. We all put in our money together, and we actually come up with a risk retention groups policy. You wouldn't match up a behavioral health with like an oncologist, right? Those are very different situations. You just wouldn't. You would have similarly situated groups in a similar bucket. So each one of these literally creates a bucket. The last but not least is going bare. Going bare means you have no insurance, and you're willing to take on whatever risk comes. For some people, that's appropriate, but for most, it's not. Since the 2003 Florida torts reform, the insurance costs have actually gone down. I don't know if you remember, like, back then they were talking about exorbitant costs for OBGYNs and so forth. Well, when they put in the actual tort reform legislation, it brought down the cost of insurance. So less and less people are going bare over time. But with that, you have to be ready to now bone up and get your own team of attorneys. There's people out there that are selling policies of just the legal side of it, and they're saying, go bare, we'll get you your legal defense counsel, but pay us for the legal defense counsel in advance, so you don't have to pay us in case the event occurs. Well, that I like the idea. As a business guy, I'm all for it, because that's where I would make a lot of money. But frankly, it's not the right thing for the client. What that means is, if an event occurs, that law firm is literally picking up, it wants to shut down that case as quickly as possible. They have zero incentive to let that case go on any longer than they absolutely need to. So they will make, and push the other side to go settle up that dispute, because they don't want to expend any more legal resources on it. That's why going bare to me is like the last option. You got to also plan out your own wills, your trusts, and all that. So if you've got a physician that's like, looking to go bare, you got to do the whole asset planning. I mean, I do help physicians with that, but that's for not, but I typically don't do it for going bare purposes. It's because, they've accumulated a lot of wealth, and they got to just be feeling secure with it. So going bare, it's an option, and you can always use it. So that's all I'll say about that, other than, saying anything else. Now keep in mind,
going bare is also going back to my comment about making it second nature for you in your practice. Going bare is probably the least amenable to that. It's really hard to make it second nature in terms of risk management.
And going bare also means you're going to manage your own claims. Anytime there's a claim, now you got to manage and negotiate with the other side if you can settle it out of court or not, pre-litigation, right? So going bare has other things to it that you got to be ready for. So anyway, just the importance of this slide is, know that you got more than just one option, which is to buy insurance. There are other options out there, and you got to think out of the box a little bit to see what you want to do and what's appropriate for you. If you've been in a part of a large size health system, they pretty much almost always have option number 2, which is the self-insured retention funds, right? The self-insured funds. That's almost always it. The risk retention groups, they happen to, but not as often. All right, so another way to actually minimize your risk and risk management issues is by pushing the blame off to the other side, or insulating yourself through legal clauses. So you can actually take legal clauses that work to your advantage to limit the amount of liability you take on, right? You meaning your company. And that's typically done through the indemnification, release, and waiver agreement, or the liquidated damages and limitations clause. Those paragraphs will have in it how you can limit and insulate your liabilities. You can also put in there provisions regarding insurances that you're requiring the other side to carry and what you promise to carry. You can actually add a access to books and records clause to give you a level of transparency, so you can actually see what's going on and who's the right person that should be taking the blame for it. And there's a whole lot of other things you can do in terms of legal contracting clauses. They really help you insulate and isolate these situations as they occur. And so, keep that in mind. That's one of the things in your arsenal. That's almost, if you go back to this slide, that's actually This travels in parallel with any of these options that you do here, 1 through 5. If you do any of these options, this legal clause hedging screen that I have, it travels in parallel. It's not a separate thing. It's something you do parallel. Okay, so just know that. All right, so what's on the horizon right now, right? Obviously, telehealth is here, the infrastructure, the connectivity, and all those issues are changing, right? And that's evolving. But let me take you back a little bit. Let's go back to electronic health records. What's going on with your electronic health records? I think that there's a level of exposure in almost every organization for electronic health records. If you've got a drop-down menu and you're clicking on stuff and flying through it, and you're copying and pasting right into like the patient files as to what was done that day, and you've got auto-populating that's going on, you may be over-documenting. And what I mean by over-documenting is you may have listed way too many things that you actually did not do. And it makes it look like you actually ran a particular type of, let's say, a blood test, or a particular type of a PSA, or, you know, a scan that you did that you totally did not even read, and you missed it. And now it's showing up in there. Guess what? You've got a responsibility for that. Now that you've documented it, holy cow, it's over documented. So yes, documentation is good, but bad documentation is really bad. So you got to balance it out. Another thing to look out for in EHRs is metadata. Metadata tells you how often a record was opened, who it was opened by, on what dates, and so forth. So going back and manipulating records cannot and should not happen. You know, if there's a modification to what was originally stated in an electronic health record, go in and put in an addendum after it and change the actual decision of what was decided, let's say, a few days earlier. But put in another note that's separate and apart, but related to that note, that's important to note in that patient file. You know, cybersecurity, like Charles had mentioned earlier, like cyber insurance. What happens to cyber insurance, right? That was obviously one of those things that wasn't on that slide, but it has to do with hacking and even internal breaches, right? What if somebody internally goes in and downloads does a whole data dump onto a, you know, whatever, onto another cloud, onto their own little USB. Now you've got a whole internal hacking that's happening, not just the external stuff, right? So you need cyber insurance for that. You got to make sure that you're covered for it. And then there's cost of notification and credit monitoring that goes each time that flow with it, that are incurred each time that there's a cybersecurity breach. So you got to figure out, what is that? What's that going to cost you? What if it's a 500-person breach? What if it's a 500 records breach? What if it's a 500,000 record breach? You know, the levels are very complex. Again, in this, what you got to consider is, should I get cyber liability insurance? And you got to have a breach response plan. The breach response plan will give you step 1, 2, 3, 4, 5, what you got to do, who you got to invoke, who you got to like notify. And you're going to do this in line with your whole boat. Remember the boat that we talked about in the early on with all these different departments? They got to work with each other to figure out on how that cyber breach response plan will work. You can't do it obviously without your technology people. You definitely can't do it without your compliance people. You got to involve all these other different administrators to make sure that you've got the right plan in place. Okay.
You know, and you're primarily focusing on the electronic health records issues and with cybersecurity, but you also have to pay attention to your telehealth visits as well. You know, you want to make sure that the policy covers your telehealth visits, whether it's virtual video conferencing or teleconferencing. All of that is also, you know, important to be covered.
Good point. Good point. All right. Now this brings me to the last phase of what we're going to talk about. We're actually up to, as you can see, practice tip number 10. Sorry, number 9. And so this is what happens when all goes south. And now let's say you've got your system set up, you've done your internal management sort of stuff, you've done your whole risk management, you've done your insurance policy buying and all that. And let's say you get a claim. That claim will typically have in it the word negligence for something, okay? And so here's, the elements of a claim are typically duty, breach, cause, and damages, okay? Duty being you had a duty to safeguard my records, or you had a duty to review my test results, and then you failed to do so. That's the breach component. That caused me, or my patient, to now suffer a specific harm. Let's say that, the ovarian cancer or prostate cancer or kidney issues exacerbated, right? Or went really way south. Now you've got a whole damages component to that. And then we can talk about damages and all these things. By the way, we are going to touch on this stuff in another seminar in 1 month from now. And we're going to talk about the anatomy of a lawsuit. So we're going to touch on this and then a lot more of how a timeline will work on this. So keep that in mind. Sign up with actually South Florida Hospital News. They are the ones that are hosting that, and it's coming up in 1 month roughly. So now the types of allegations you will see is things like failure to timely read test results, like we talked about earlier. Failure to refer. How many of you know of a referral department that's sucking air? Like you should have referred out a patient literally that same day, and it took 2 weeks to get a referral done. There's a problem with that. There's a delay in it. It's an undue delay. Now, how many times have you seen a referral that actually never even got referred out? It was said that they were going to refer it out, but it never got referred out. These are real issue, people. These are real issues. And then I have a whole stream of other things that could go wrong. You could have a misdiagnosis. You forgot to order a diagnostic test. There was a delay in treatment. A medication from one patient got mixed up with the other patient, and you've got issues. It goes on. There's so much so if you're inside a hospital system, if you know that a patient can't walk safely and so forth, there's a duty to actually watch that patient so that they don't fall, right? Because they're in your care, they're under your roof, they're part of your, you are a part of the reason why they went there, because they were afraid that, there were other issues going on, but they may fall. So patient fall is like a critical component of this. So why not? So anyway, that's what's there. Now, when it comes to actually defenses, there's a whole slew of defenses. I actually have a book of just defenses, right? And I work on these books of defenses. Like if I go through an actual case, I will tick and check, and figure out exactly what defenses there are. So much so I usually put in about 25 to 30 defenses that I can put up on behalf of my client to say, this is why this lawsuit should not stick to my client. And one of them to keep in mind is actually what's called captain of the ship doctrine. Captain of the ship doctrine basically means that the physician is the captain of the ship. So if it's not your physician, you're going to do one of these, right? You're going to point the finger the other way to the other physician, or to the other entity, or to the other administration, and you're going to push the blame over. That's how you defend these sorts of cases. There's also what's called a statute of limitation. Statute of limitation, I love that defense only because it's got an absolute bar in terms of time. And you got to figure out how that timeline works. And you can literally defend against a lawsuit just based on that one specific situation. Even if the claim is 100% accurate, statute of limitations will allow you, if you can actually invoke it the right way, to stop that claim. So my advice to you would be, as risk managers, is take a look at your patient complaints. What are the patients complaining about? That's going to tell you where your holes are. That's going to tell you whether you look at, you can start off with Google reviews. Google reviews is just the beginning of it. But internally, what is your front-facing staff towards the patient? What are they hearing from the patients? What are the patients complaining to them about? I would bring them into the mix. I would take a look at the reports that you filed with the Joint Commission and what was reported on it. What is the TJC looking for? You need to know that, and you need to hedge against those kinds of things that are showing up. It's absolutely critical that, these kinds of things get considered, and you think outside of yourself. You got to think about enterprise-wide. How does it affect people? It's a conundrum. Now,
a key component of that, of being able to assess what your patient complaints are, is developing a culture of communication. Communication with your patients, communication with your staff, communication with the right professionals in your circle. having the right resources and communicating with the professionals there. You know, it's one of the major tools in risk management is maintaining proper, thorough communication.
Now, I'll say something about communications, right? So a lot of employees get dinged for communicating. And I tell you, I'm a guy of like the 90s, right? In the 90s, I think the corporations were much more flexible and open to employee input. I think that as time passes, they're getting less and less open to it. And there are terminations that happen just based on the fact that the employee reported back something that the enterprise did not like. You got to really watch that because, yes, there are complainers. I agree with that component too. There are complainers out there and that'll complain about just about anything. And they'll say the sky's falling, the sky's falling. But there are legitimate complaints that come in and people do get fired for those for no reason at all. So be mindful of that. Do the right thing. So, all right. So now let's talk about, you did all this stuff. A particular patient went through something. Let's go back to the same scenario that we talked about where we missed the whole blood test results, right? That reading and the communication back to the patient. So what's going to happen is that a claim is going to arise. The first thing you look at is that claim based on contract or is it based on a tort? Like I said, if it says negligence of something, it's almost always a tort. Okay. If they say breach of like failure to perform, no, even those, no. Again, if it's not based on a particular document or an agreement, then it's generally considered a tort. So that's your rule of thumb. For us lawyers, let us do the fine sifting when we do get that sort of a claim. But as soon as it's actually a tort claim, again, then it's time for you to push it along to your insurance company and see if they'll cover it. And they should cover almost all tort claims that come up. What's going to happen is you'll send it to your carrier. And you're going to make sure that they pick it up and they provide you a defense. It's called a duty to defend. There's a duty to defend that's triggered by you submitting it to the insurance carrier. Now, I'll tell you this too. I've seen it where the insurance carrier forgot to assign it to a law firm, and the enterprise got defaulted and a final judgment against them worth like $500,000, and there was nothing done on the to the other side, like literally a slip and fall and like in the middle of like a parking garage, right? So stupid stuff like that. $500,000 gone, right? And that's because the insurance company forgot to assign it to an attorney. So keep an eye on it. Then the insurance company is obviously responsible for that nonsense, right? But make sure that you stay involved, that you're monitoring your claims. And when they do get you legal counsel on it, make sure that it's actually competent legal counsel that's actually done this kind of defense work. Most good insurance companies do hire good legal counsel, but those legal counsels, just keep in mind, they get paid the longer that lawsuit drags out because they're billing by the hour. So what you need to do is you need to actively manage that legal team and push them to shut down the case as quickly as possible. And that's where, you get your own administrators who are pretty smart about it, maybe your own in-house counsel, or maybe you get people like us on the outside that actually just literally come in to represent the enterprise or the actual physician. And then we push the actual insurance attorneys at literally a fraction of the cost. And then the fourth step I'll tell you is most lawsuits will reach a point of settlement, right? So whether to settle a case or whether to go on to trial, and there's a whole cost benefit analysis that goes into that. You got to think about the nuts and bolts of what it's costing you, not just in terms of attorney's fees and time, but what are you losing along the way as your opportunity costs, right? What are you missing out on? What were you not able to focus on? How could you have redirected your staff to focus on that opportunity that's out there? So you got to do that. Anyway, this is my last one, and that tip number 10. Before settling, know how that settlement affects your license and know how it affects how that settlement will be reported in the actual National Practitioner Database. Without it, do not settle. Do not settle. I urge you, do not settle without knowing the answer to that question. Tip number 10 is by far one of the most important things I could tell you on here, is you got to know the answer to that. With that said, we are healthcare law partners. If you have a particular contract or a dispute, the way to reach us is call us or email us, send us over the key documents. We'll review them with you. We'll even give you a legal fee estimate, and we'll help you get that issue resolved. But nonetheless, any questions on what we just talked about?
Thank you, Ben. Did we have any questions? Just unmute yourself and go ahead.
And we actually offer the counselor call program, which is fantastic for risk management purposes. We're available to our clients 24/7. And if you would like more information on that, feel free to give us a call or shoot us an email.
This is Joe Romley. I've got a question back from slide 9 when we were talking about recruiting and the option of paying the tail. And actually, I think the discussion was being able to add a new physician to the existing insurance rather than paying a tail. I never knew insurance companies could do that for someone who wasn't part of the organization. I've been involved where the tail to come over to the company would be like $30,000, and the physician couldn't pay that amount, and ultimately didn't come with us. But I never thought of trying to add them to the policy.
Yeah. Thanks for pointing that out. Yeah, no, I've seen that happen, and it does happen, but you got to ask for it. Not all insurers will actually cover that, but some do. And it's a question worthwhile asking, because it gets rid of all those cobwebs. Your HR recruiters would love that policy. Your physician recruiters would be all over it, because this would be probably, instead of even offering them, let's say, a paycheck of whatever it is, $300,000, they would probably lead with this. Instead of the $300,000 paycheck, they would say, here, you guys can come to us, Mr. Physician, Mrs. Physician, you can come to us, and we will get you tail coverage from your prior employer over to us. It's a great benefit. It's a huge relief. Physicians are super paranoid. They have a low tolerance for risk. Well worth it. Thanks, Joe, for actually pointing that out.
Sure. One more question on that. If they then left the new employer after 2 or 5 years, what happens to the prior service? Is it now on the new employers or now the old employer's policy?
Well, it's gonna go on to probably the new policy, hopefully, or they may have, like, let's say somebody comes in from a prior from employer number 1 to your employer, and then within 6 months they move on to another. Well, I don't think it continues on. I think that it only stays there while they're there with your employer, with your company. If they move on to somebody else, I think they better get their own tail coverage. And that's how we've always framed it in the actual employment agreements as well. If you're with us, we'll get you the carryover tail coverage from prior. I've actually never been asked that question, what you just asked me, but I think that's how it would play out.
Thanks.
Sure.
Any other questions?
This is John, not a question, but a comment. I want to commend the two of you for really taking what I think is complex subject matter and simplifying it so it's actually digestible. So again, great job. Thank you so much.
Thanks, John. Appreciate it. Coming from you, that's a big deal, man. That's awesome.
You folks rock. Thank you.
Yeah.
Okay, if you have no other questions, I guess we'll kind of wrap it up now. Ben, what is the next program you have in 2 weeks? What's the next one coming up?
The next one is actually more towards legal checklists. What are the kinds of legal checklists you should have, or your in-house legal department should have? And if you're managing the whole legal process internally yourself and you're going to an outside counsel, it'll be great. You need to understand what are the checklists you need to have in place. The idea for that came from this book, Checklist Manifesto, right? So every department has to be driven by a certain amount of checklists, and the legal departments in our industry, frankly, just do not have enough checklists. They travel like they're just artists, walking through a corridor of like an art gallery. No. This is a straight up business, guys. You got to do the implementation of checklists and run this thing like a business. Not enough attorneys run these enterprises like a business. They're all like sitting there like talking about this, esoteric, philosophical, legal principles. But no, I mean, it's a business, guys. Like a lot of lawyers don't run it that way. And that kind of bothers me. So I really wanted to talk about it. And I wanted to have a whole seminar on that. How do you gear yourself up so you can protect yourself legally, whether you're managing the legal process internally yourself or you're having an outside counsel do it? That's the next one. And I think that's like the first Tuesday of March.
Right.
And then the third Tuesday of March, we have one, it's called The Anatomy of a Lawsuit. And what happens when a lawsuit gets filed, right? So all of us go into this whirlwind, like, oh my God, I got this lawsuit dropped on me. What am I going to do? And, rightfully so, because it takes a lot to fight a lawsuit. There's a lot of personal anguish in it and all that. And there's a lot of sleepless nights, especially if you've been named in it. There's ways to address that. And I think it's really, really important. So that's going to be on the third week. And I'm trying to invoke people's legal departments to actually reach out and think about these things, because they're not thinking about it, guys. These guys have, and if they are, they haven't acted on it. So you got to push your legal departments to start thinking about these things. Hugely important to organizations. They could help an organization sink or swim. Anyway, I'll stop there.
Great. Well, Ben, I appreciate it. Como, I appreciate it. And
Thank you,
again, we have the next one coming up on March 2nd and March 16th. And we do have the tax seminar coming up on Thursday. You can register for all of that on my website. If you look at the menu on the left-hand side, go to upcoming events, and you'll be able to register that way. Again, I want to appreciate everybody coming today, and hopefully I'll see you Thursday. If not, maybe the following on the 2nd, on March 2nd, for the next legal, as one might say, lunch and legal work. So, Ben, Como, thank you much, and thank you everybody for coming.